for today's class, we'll talk about the sources of administrative law. And we have the Constitution, legislation, and case law. We have talked about the Constitution of Kenya 2010. It provides for the executive, the legislature, and for the judiciary. The Constitution also provides for the offices. We have the Senate, which also passes laws. Currently, there is a bill in the lower court that seeks to prevent the naming of roads for basically what they're seeking to do. It's a bill being debated that you cannot name roads after people who are alive. Once it is done, a bill may pass and an act may come into place. The Senate is under the Constitution. All these offices that have public bodies, we have the county governments in Kenya for the various counties, they're under the Constitution. Their offices are provided for under the Constitution. And we talked about administrative law being law that is used to govern the people. They come up with, we talked about bylaws, we talked about quasi-judicial, subsidiary legislation that is formed by these bodies that are created under the Constitution. We have talked about legislation. We talked about the lawmaking process, whereby a bill is introduced, a bill is debated, and a bill is passed into law. These bills govern us. Once they become acts of parliament, they govern us. We have the Accountants Act that governs accountants, as you will be once you finish your training and you're registered with ISPAC. It will govern your conduct. We have the Companies Act. It governs how companies are formed, how companies are operated. All these stem from laws that were passed for us. How we are able to relate with each other. We have talked about contracts. We have contract laws that govern the remedies that are there once a contract is formed. What remedies can be put in place? We have the Land Act. All these are legislation, and they seek to govern our relationship, not just with each other, bodies with which we vest the power to govern us over. We have case law. We have referred numerous times to Mirugi Kariuki. This case, it is a civil appeal of 1991, and it is still relevant today. It is a source of administrative law. And we looked at what we were saying, whereby a ruling is not just a ruling. It does not simply say that your appeal has been considered and you are successful. No. It is a page document where it starts with the history, what happened here, 8th October, arrested in his home. He sought permission for Michael Esquire, Queen's Counsel, to appear. Goes ahead and says that Section 10 was repealed. You see, case law provides this. It talks about what has been repealed, what is no longer relevant today. It talks about what is relevant today. Every time something happens, it continues to be updated to reflect the current status of where we are. It continues to give us the reason for the ruling. And what was relied upon. The appellant has put forward 18 grounds, and the Court of Appeal decided to rely on 1, 2, and 18 as being pertinent. And finally, you see, we still relate to David Olo Onyango versus AG, case of 1986. It is still relevant in as far as the principles of natural justice relate to us. You see, finally, it comes and gives that we are in no doubt that the appellant ought to have been granted leave to apply orders of certiorari and mandamus, what we will go through in a bit. So these are the sources of administrative law. So once the rights that you give up as a nation and you are governed by the bodies that are in power, constitutional bodies, what happens when they do something that you feel they should not have done? You have remedies. And which remedies are these? We have various types of remedies. We have talked about appeals. Appeals relate to case law, whereby the judicial system has the various courts. We will go through the courts. The first court that your matter is heard, if you feel that this matter, that your rights were infringed upon, you appeal to the next court, the High Court. Once you appeal to the High Court and they uphold the ruling of the lower court, you still have a remedy. You go up to the Court of the Appeal. And finally, up to the Supreme Court, the current highest court of the land. We also have judicial review. And it's in judicial review that we have the Constitution giving us 2 instances. And it talks about the legality and enforceability of decisions made by tribunals and lower courts. Judicial review takes place during 2 instances, where an action is ultra vires. And again, we go back to the breach of the rules of natural justice, the right to be heard and the right against bias. In that ruling of Mirugi Kariuki, he was granted leave to apply for certiorari and mandamus. It was a judicial review case. The other type of remedies are prerogative orders. We also have equitable remedies and we have ordinary remedies. So today, we start with judicial review. Initially, before the Constitution that we passed in 2020, judicial review was merely a remedy and administrative law. But right now, Article 47 of the current Constitution provides that every person has the right to administrative action that is expeditious, efficient, lawful, reasonable, and procedurally fair. This means that you as an individual, it is not only your administrative right, it's your constitutional right that if you feel any of your rights envisioned in the same Constitution, the right to life, the right to congregate, any of these rights are not protected, you have a right to again go back and fight for them. Judicial review remedies. Their best common law may provide a right to damages, restitution, or recovery of a sum where there has been unlawful administrative act. So when you talk about judicial review, we talk about the supervisory jurisdiction of the High Court to review the decision of an inferior tribunal to determine its conformity to the law. We talked about the legality and regularity of a decision and a failure to act. So wow, our first question is, what is jurisdiction? Courts have the jurisdiction to review the decisions of public bodies under the common law remedy known as prerogative writs. We had talked about writs whereby they are written down, they are procedures. So courts have that constitutional, they have that jurisdiction, they can review. And we talk about judicial review and the Constitution. The Constitution provides, as always, is supreme. And a case whereby that relationship of when the Constitution was questioned is Gladys Moneki versus Gordon Olwot. And in this case, the petitioners filed a constitutional reference to contest the decision of the Kenya Taekwondo Association to select participants to the All African Games. So the petitioner Gladys Moneki and the 6 others felt that the Taekwondo Association was discriminatory. It denied them a chance to participate, and that in denying them a chance to participate, it was against their constitutional rights. And therefore, they wanted the whole selection to be declared null and void. What they wanted, and the court had agreed that the matter could be heard. But Gordon Olwot and the 7 others, they objected to the jurisdiction of the court. And they argued that the Sports Act provided for a resolution within the tribunal. And the courts agreed that where statute provides a remedy, the mere fact that the facts of the case can fit within a claim for the violation of the Constitution does not give rise to an action in constitutional law. What does this mean for us? That as much as the Constitution in Article 47 provides us that remedy, that if today I feel aggrieved, I cannot just go to court first. I need to look at the action that is taking me to court. We have talked about the Companies Act, we have talked about the Accountants Act. All these acts within themselves have remedies within them. So right now, if something is to happen, or even the Contract Act, if that contract with George Otieno and myself, we had provided that, should we not agree before we take each other to court, we can have an arbitrator. I cannot jump the gun and take him to court. The court will tell me that, yes, my constitutional rights may have been infringed, but it does not mean that the contract I entered into cannot be, it will be read against that contract. I will be referred back to that arbitration that I had agreed upon. Literally speaking, you cannot jump the gun because your rights for judicial review are enshrined in the Constitution. The same Constitution provides the remedies. It also provides the procedures. We have talked about the sources of administrative law, case law, and legislation. Legislation has given us the Civil Procedure Act and the Civil Procedure and the Criminal Procedure Act. They have rules and regulations, how to go about it, such that as much as my rights are supreme, your rights are also supreme. So where do we meet and ensure that we both follow the law? We talk about the contracts we enter into, and in such a case with Gladys Moneki and the Taekwondo Association, that Sports Act provided the procedure for resolution. So the same law that gives us the right to seek remedies also gives us the procedures for seeking these remedies. And procedure ensures that there is no overlap. It also ensures there is no back and forth. That if I take George to court without having gone through the arbitration, he will also take me to court because I did not go through the arbitration. Do you see a place whereby we are ever in court fighting against things that we had agreed to, yet none of us wants to follow the procedure. So the essence of judicial review, the essence of any remedy in administrative law is that the procedures must also be followed. But if the issues that are there are constitutional in nature, then the Constitution will provide the remedy. And we have CCK versus Royal Media Services, where the Supreme Court, in 2014, the Supreme Court recognized that the power of any judicial review, yes, it's found in the Constitution. We have the Republic versus Director of Public Prosecution, ex parte Kamani of 2015. And the court held that the grounds in judicial review applications be developed, and the grounds for granting relief under the Constitution and the common law be fused, intertwined, and developed so as to meet the changing needs of our society in order to achieve fairness and secure human dignity. And they went further and said that care should be taken not to think that the traditional grounds of judicial review, that they have been discarded. As we were saying, that the rules will be followed. We have the civil procedure rules. They will not be discarded because you feel that you have a right under the current Constitution. In other words, the law will follow what is set out. Traditionally, people assumed that judicial review was a public law remedy because of this aspect of administrative law. We said that administrative law is public bodies governing us. Public bodies being put to you put them on the stand and ask them, if we have given you this mandate to govern us, if you do not govern us in a way that we feel our rights have been protected, then we seek redress. So judicial review was assumed to be simply about public bodies because of administrative law. But we find that the scope of fair administrative action and judicial review also talks about private persons of bodies. And judicial review should focus on the exercise of power irrespective of the source. And this means that whether the powers are public, whether or not the powers were public, but the very exercise of the power had the potential to adversely affect individual rights, then judicial review will be implemented. And we have the Republic versus Kenya Cricket Association, whereby the applicant brought judicial review proceedings seeking orders of certiorari and prohibition against the Kenya Cricket Association. And it was held that judicial review does not lie against private bodies, but arguably, we say that the horizontal application of the Bill of Rights extends the remedy of judicial review to non-state actors. This is why we have these bodies that they can be sued if their actions infringe on not only an individual right, but public rights. We had talked about two issues whereby legality and enforceability of decisions made by tribunals and lower courts. Those two instances whereby the action is ultra vires and the breach of the rules of natural justice, that is the right to be heard and bias. So we talk about what is ultra vires. The doctrine of ultra vires is whereby the power of the government is derived only from law, not from usage or estoppel. And the government must be according to the law. You cannot today wake up and the government cannot today wake up and decide it won't follow the law. It must act within the same law that has established it. So what do we say is ultra vires? We have Lord Camden who said, if it is law, it will be found in our books. If it is not found there, it is not law. Basically, we have the Constitution, we have case law, we have legislation. Anyone or anything that purports to act from those three tenets has acted from something that cannot, there's no basis where you act against what does not exist. In the simplest terms, you do not exceed the powers that you've been delegated to them, and you act within those powers. This means that for anybody that is given authority to pass laws of parliament, they can only pass the laws that follow the procedure. The bill is brought, the bill is debated, the bill is published. The public is made aware of what is being done. They cannot do things without involving the public, because the law provides that the public must be in the know of what is happening in the day-to-day. Once that happens, then they will have acted against. Ultra vires is going over and above what is provided for you. It also talks about protecting third parties. We have talked about contracts. If, for instance, I have no capacity to contract with you, George, because maybe the contract that I want to enter into is illegal, you are protected because I have acted beyond my capabilities. I have no legal standing. I cannot act against what I do not own, what I do not have. It's derived from Latin. It means beyond the powers of. Any transaction or activities beyond the scope of the authority endowed upon this particular body, this particular arm of the government, it cannot stand, because you cannot act without that which gives you the authority to be in place. The state may do nothing but that which is expressly authorized by law, while the individual may do anything but that which is forbidden by law. What does this mean? Well, you and I can basically do anything that we assume we have the right to do. We have the penal code that prevents us from going over and beyond, from infringing the rights of another. Well, I am allowed to do what I am allowed to today, wake up and travel to another county. I'm allowed to today wake up, as long as I have the proper documentation in place, to move and work in any other place, not just where I am right now. But what is forbidden by law is you going to do something illegal. So the individual can do anything but that which is forbidden. For the state, it may do nothing but that which is expressly authorized. Why do we have the judiciary? To uphold the Constitution. Literally to uphold the Constitution, to ensure the rules of natural justice, to ensure the rights of the people have been upheld. So it can only do that which is expressly authorized by law. Currently today, we have the penal code. You cannot be charged with an offense that is not in the penal code. So the state cannot one day wake up and purport to charge you with an offense that does not exist. So the state, in this doctrine of ultra vires, can only act within the powers that the state has been given. It cannot go beyond. We have the Republic versus KRA, ex parte Aberdare Freight Services, whereby the court held that the general principles remain. A public authority may not vary the scope of its statutory powers and duties as a result of its own errors or the conduct of others. Therefore, where the law exhaustively provides for the jurisdiction of an executive body or authority, that body or authority must operate within those limits and ought not to expand its jurisdiction through administrative craft or innovation. The courts would be no rubber stamp of the decision of administrative bodies or executive authorities. Whereas, if Parliament gives great powers to them, the courts must allow them to do it. The courts must nevertheless be vigilant to see that the said bodies exercise those powers in accordance with the law. The administrative bodies and tribunals or boards must act within their lawful authority, and an act, be it of a judicial, quasi-judicial, or administrative nature, is subject to the review of the courts on certain grounds. They must act in good faith. Extraneous considerations ought not to influence their actions, and they must not misdirect themselves in fact or law. Most importantly, and this is where we insist, they must operate within the law and exercise only those powers which are donated to them by law or the legal instrument creating them. So that case provides the administrative bodies in this case of the Republic versus KRA cannot act further than the laws. You cannot extend your authority. You can only act as per what you have been provided for to act. So when do we also talk about ultra vires? An action whereby it's taken by a person to whom the power did not belong to, or if the power was improperly delegated, either because initially there was no authority to delegate, or the procedure for delegation was improper. What does that mean? That you cannot transfer what you do not have. Take, for instance, you own a company and you have a board. In this board, or let's say you have an accountant, you have a secretary, you have your messenger, and you have separated the powers, whereby you have separated the duties, whereby your accountant does your books, your secretary does your paperwork, your messenger does the errands. If your messenger signs a check on your behalf and that check goes through because probably the other party did not confirm, that messenger had no authority, had no power, because you cannot delegate what you do not have. The accountant may have an accounts assistant, and this accounts assistant may have been given ledger work, whereby if today we sell this amount, record it, bank, and bring the banking slip. To that extent, he's allowed to go to the bank. He's also allowed to take the check. But this messenger cannot purport to do any accounting work for you. So he would have acted beyond the scope of his responsibilities, beyond the scope of his work. That is another instance whereby an improper delegation. And we have Geoffrey Kiragu Njogu versus Public Service Commission. In this case, the appellant is an assistant chief. He was charged in a criminal case for corruption, and the appellant was interdicted by the public service, and he was paid half of his salary. So the second respondent, who was by then the provincial commissioner, informed the appellant of the first respondent's decision to retire him in public interest with immediate effect. Public Service Commission wanted to retire the assistant chief because of public interest. But Geoffrey with public service to reconsider the decision and wait for the outcome. Geoffrey was charged in criminal court. Before the matter was heard and determined, his salary was, he was paid half. He was relieved of his duties and he was to be retired due to public interest. But he pleaded with them to wait for the outcome of the case. Fortunately for him, he was acquitted of the criminal charges, and he sought his reinstatement as an assistant chief. So the district commissioner, his immediate boss, sought the chief to be reinstated. And for his salary, half salary, which had been unpaid, when on your interdiction, you're paid the half salary, which had been unpaid from February 2008. So he kept writing from 2010, 2012. And in 2012, the district commissioner informed the assistant chief that his appeal for reinstatement had been rejected and the case closed. And he was to clear and return all the uniforms and other government property. So this chief initiated judicial review proceedings, seeking orders that an order of certiorari be made to move the court to quash the decision of the second respondent, and also an order of prohibition restraining PSC and the DC from using that concluded case as a ground for retiring him. And thirdly, an order of mandamus compelling them to pay all his outstanding salary dues. One of the issues was whether the public service had the decision to reinstate a public officer after suspension, whether the public service the powers of the public service. The public service is the human resource body of the government. It recruits, it advertises, it trains, it does all these things that relate to HR. So the question was, could these powers of reinstating the assistant chief be delegated to the DC? And it was held that the DC had no power to retire a public officer, and the letter he wrote could not be construed as a retirement letter. You must also note that judicial review is concerned with the process, not the merits. We talked about the procedures that lead to a decision. So judicial review will consider that and not the decision itself. That is why in that case we have heard of the assistant chief and the public service and the DC. We talked about a letter. Could the DC purport to write a letter on behalf of the public service? Did he have the delegated authority to do so? And the matter was held that no. That letter that the DC wrote on his own accord. The public service never delegated and therefore never authorized him to retire the assistant chief. So judicial review will talk about the process that was done. It will talk about the reasonableness of the act. And when a decision is unreasonable, courts tend to assume that there is no way that the procedure was followed if a decision is held to be unreasonable. Accordingly, even when attacking the reasonableness of the decision, the court will still be concerned about the process that led to the decision itself and not the decision. That led to the decision, but not the decision itself. You see, in the cases we have talked about, the decision is not questioned. The procedure is questioned. The assistant chief never questioned he appealed against the grounds of being retired in public interest, but he never questioned being retired. But the procedure was what he questioned, whether public service had given this DC the authority to retire him because of public interest. So judicial review follows that, where they feel a decision was unreasonable, then they feel the procedure must not have been done and must not have been taken. We talked about the principles of natural justice, and this breach of the rules of natural justice, specifically the right to be heard, is held in very high regard. It is where most of the judicial review actions stem from, and that of bias, where the individual feels the individual has shown that natural justice, he was never given a chance to be heard, and the case was not properly determined.